Namaskar and welcome to this explainer. Look, today we're not just reading dry statutes. We are diving into an absolute masterclass on one of the oldest, most intricate personal law systems on the planet, Hindu family law. Mark my words, we are looking at the very legal fabric of a billion lives here. From the exact second you take your first breath, to the sacred fire of your wedding, right through to the disputes that can tear homes apart, and finally, the legacy you leave behind. It's a complete, cradle-to-grave legal framework, and we're going to unpack it all.
Okay, let's dive right into this. We'll be tracking 5 key milestones today. We'll start with the joint family, move on to marriage, then tackle matrimonial remedies, look at adoption and guardianship, and wrap it all up with succession.
So let's start at the very beginning, shall we? Unit I, being born into the joint family.
Now, Hindu law doesn't just come out of thin air. Its foundation is rooted deep in ancient texts, the Shruti, which are divine revelations, and the Smriti, the rulebooks of conduct. And from these texts, the law basically split into 2 major schools of thought. The contrast here is absolute. On one side, you've got the Mitishar school, which covers most of India. Under this, a son acquires an interest in ancestral property the literal second he is born. Boom! Right by birth, governed by survivorship. But then, over on the other side, mostly in Bengal and Assam, you have the Dayabaga school. Here, a child has zero interest in the property while the father is alive. Inheritance only kicks in upon death, based on who provides the most spiritual benefit. It's a night and day difference.
Now, if we zoom in on the Mitokshara joint family, there's this very specific, exclusive inner circle called the coparsonary. Historically, this was just the male members across 3 generations who held that powerful birthright to the property. And who runs the show? The Karta. You can think of the Karta as the absolute CEO of the joint family. But listen, his power isn't a blank check. He has what we call the power of alienation, meaning he can actually sell or mortgage the family property, but strictly only for legal necessity, the benefit of the estate, or indispensable religious duties. He binds the family, sure, but only when it's truly necessary. And this brilliantly illustrates how ancient concepts evolve with the times. For centuries, daughters were totally shut out of the coparsonary. But Parliament stepped in with the 2005 amendment. Then, in 2020, we got the landmark Constitution bench case of Vinita Sharma versus Rakesh Sharma, and the Supreme Court laid it down with absolute, undeniable clarity. They declared, a daughter is a coparsoner from birth. She has the exact same rights and liabilities as a son. They made it crystal clear, this birthright is statutory and independent, an absolutely massive historic equalizer. So you might be wondering, how does this joint family actually break apart? Take a look at the case of Guru Nanak Industries versus Suraj Prakash. You know, surprisingly, you don't actually need a massive, dramatic courtroom battle over assets to sever ties. Nope. All it takes is a clear, unequivocal declaration of your intention to separate. Once you communicate that to the other coparsoners, it affects a partition in status immediately. One unilateral communicated declaration and boom, your joint family status ceases.
All right, so the individual is born. Their property rights are locked in. But what happens when they come of age? When entering the sacrament of marriage, what actually makes it legally valid?
Well, that brings us right to Unit 2, the sacrament of marriage.
Under traditional Hindu law, marriage, or viva, isn't just a contract. It's a religious duty. It's a sacrament, the final of the 16 samskaras. Now, the Hindu Marriage Act of 1955 kept that deep sacramental vibe, but laid down some really strict legal boundaries. Let's run through Section 5 like we're standing in a courtroom. There are 5 absolute conditions for a valid Hindu marriage. 1. Strictly monogamy. Neither party can have a living spouse. 2. Valid consent and complete mental capacity. 3. The groom's got to be 21 and the bride 18. 4. They must be outside the prohibited degrees of relationship. And 5. They cannot be sapindas, meaning closely related lineal descendants, unless a recognized custom permits it. You violate these, you're inviting the full wrath of the law.
Moving on, we absolutely have to talk about the 2006 case of Seema versus Ashwani Kumar. See, back in the day, a lot of marriages just went undocumented, which frankly led to massive fraud and the denial of women's rights. The Supreme Court had enough. They stepped in with a powerful, impartial mandate, using their extraordinary constitutional powers to order every single state in India to make marriage registration compulsory. This isn't just bureaucratic paperwork, guys. It is the essential documentary armor needed to protect vulnerable individuals. So, the crucial point here is, you literally cannot game the system. Look at the landmark judgment in Sarla Mudgal versus Union of India. We had situations where Hindu husbands were actually converting to Islam for the sole purpose of bypassing Hindu monogamy rules so they could take a second wife. Well, the Supreme Court struck that down with an iron fist. They firmly ruled that converting to Islam does not automatically dissolve a valid Hindu marriage. Because of that, the second marriage is void ab initio, void from the very beginning, and the husband is criminally liable for the grave offense of bigamy. The sanctity of that first marriage, it remains entirely intact.
The law fiercely protects the union, for sure. But we have to be realistic here. What actually happens when the sacrament breaks down? When the home turns into a battlefield? This ushers us right into Unit 3, Matrimonial Remedies and Divorce. When things fall apart, family courts step in with highly structured mechanisms. They even provide maintenance pendente light, ensuring no spouse is left totally destitute while fighting their legal battles. Now, the law actually offers escalating tiers of relief way before we even hit the divorce button. First up, restitution of conjugal rights. If a spouse just packs up and leaves without a solid excuse, the court can legally order them to resume cohabitation. If things are a bit more far gone, we move to judicial separation. The marriage still exists on paper, but the legal obligation to live together is suspended. And then there's voidable marriages, basically an annulment where a legally formed marriage is completely wiped out by a judge because of things like fraud, force, or impotency.
Now, if the marriage is truly undeniably dead, the most peaceful exit strategy is Section 13B, mutual consent divorce. But don't be fooled, it is highly structured. You can't just walk into court and walk out single. Step 1, both spouses have to live separately for 1 full year. Step 2, you file a joint petition officially declaring the breakdown. And Step 3, the law forces a mandatory 6-month cooling-off period. Why? Because the law wants to give both parties ample time to step back, cool down, and really think it over before that final, irreversible decree is passed.
But what happens if one spouse just refuses to consent out of sheer spite, even when the marriage is clearly a hollow shell? Let's contrast two absolutely massive rulings here. First, in Naveen Kohli, the Supreme Court pointed out that irretrievable breakdown isn't actually a statutory ground for divorce under the Act. But they heavily pushed Parliament to change the law, stating that forcing two people to stay in a dead marriage is a form of immense cruelty. Then, things got brilliant. The Supreme Court decided to use its own extraordinary Article 142 powers to just cut right through the red tape. In the 2023 Constitution Bench case of Shilpa Salish, they ruled that the Supreme Court itself can bypass those statutory limits, waive that 6-month cooling-off period entirely, and directly dissolve a marriage if it has irretrievably broken down. Complete justice, delivered. All right, let's keep moving. Unit 4, Adoption and Guardianship Rules. This is all about raising the next generation. When we look at the 1956 Adoption and Guardianship Acts, we see this really fascinating empowerment of women. Consider the case of Laxmibai Chandaragi versus State of Orissa. Here, a widowed mother placed her child in adoption and it got aggressively challenged simply because she didn't have her deceased husband's prior consent. Well, the court backed her up completely. They ruled that under the Hindu Adoptions and Maintenance Act, a widowed mother has an original, totally independent power to give a child an adoption without asking anyone for permission, as long as the father didn't explicitly forbid it before he died. We see this exact same progressive interpretation applied to guardianship. Take Geetha Hariharan versus RBI. The statute literally said the natural guardian is the father and, after him, the mother. The Reserve Bank took that way too literally, arguing the mother had zero rights while the father was still breathing. But the Supreme Court stepped in and read down the statute. They explained that after him simply means in his absence from the day-to-day management of the child's affairs. They firmly established that the mother acts as a co-equal natural guardian right alongside the father. The ultimate takeaway, the welfare of the child reigns supreme, completely overriding any archaic patriarchal interpretations. And so, the child is born. They get married. They raise a family of their own. But finally, how is the legacy passed on when the journey inevitably ends? This brings us to our final milestone, Unit V, Succession and Property Inheritance. When a Hindu dies without leaving a valid will, which we call intestate succession, the Hindu Succession Act kicks in with some strict commanding math. First up, we have Class 1 heirs. These are the immediate family members like sons, daughters, widows, and mothers. They take the properties simultaneously and completely exclude everyone else. Now, if there are absolutely no Class 1 heirs, we move down to Class 2 heirs.
Failing that, the estate goes to the agnates. These are the patrilineal relatives traced entirely through the male line. If there are no agnates, it passes to the cognates, blood relatives traced through females. And what if a person dies leaving literally no heirs at all? Then the doctrine of a sheet applies, and the whole estate simply reverts back to the government.
But how do the courts make sure justice actually bridges the gap between generations? Remember that 2005 amendment we talked about, the one that made daughters equal co-partners? Well, in Denalma versus Amar, some sons tried to argue that their sisters, who happened to be born way before 2005, shouldn't get any rights to the ancestral property. The Supreme Court completely rejected that argument. They ruled that daughters born prior to the 2005 amendment are fully and retroactively entitled to equal co-partnery rights. Your status as a co-partner is a birthright, period. It doesn't matter what year you were born. So, from the ancient verses of the Shruti all the way to the sweeping constitutional powers of the modern Supreme Court, Hindu family law isn't just some stagnant pond. It is a mighty, constantly flowing river. We've traced this incredible legal life cycle from the very first breath to the final passing of the estate. But I want to leave you with this to ponder. As our society rapidly evolves and as the modern family dynamic completely shifts, how will these ancient texts, guided by the highest courts in the land, adapt next? Thank you for joining me for this explainer. I really hope you now have a solid grasp on the profound mechanics of this historic law. Until next time, keep questioning and keep learning.